So now we will go to the last panel of the day, and then afterwards we have also some closing remarks from our president. But now I give the floor to the moderator of the next session, which is our first Vice President, Roman Savacek. The floor is yours.
Thank you very much, Simone. Dear colleagues, ladies, gentlemen, this is the final session of the day. I see that many seats have emptied, but not because we are the last, but because they need to hurry somewhere. They need to catch the plane. So, as we begin this final third panel of this conference, it is fitting to reflect on the significance of the number 3. Often the most compelling ideas are conveyed in 3 key points, providing clarity and impact. This last panel is no exception. It brings together diverse perspectives that, when combined, will offer a thoughtful and memorable conclusion. Let us appreciate this moment of synthesis and progress as we move forward. This last panel will be dealing with the question of ensuring fundamental rights within the digital transformation of justice. With the increased use of digitalisation in the justice system, the protection of fundamental rights has become even more important. The panel session will consider a wide spectrum of important aspects, from policy insights, guidance to safeguard rights, and avoid pitfalls, in a special focus on best practices for the handling of electronic evidence in cross-border cases. Therefore, I'm delighted to begin this panel session by welcoming yet another 3 distinguished speakers. And I'm really looking forward to their perspectives. They will keep you alert for additional 1 hour and a half, together with your questions, and try to open additional questions in your heads. We are going to move from the institutional aspects and perspectives towards the practical perspectives, which we save for the final part of this panel. So, with a great honor, let me introduce you our 3 speakers. I will firstly start with Daniel Schmidt. Daniel Schmidt is a secretary to the Intergovernmental Working Group of Cyberjustice and Artificial Intelligence of the Council of Europe's European Commission for the Efficiency of Justice, known by the acronym CEPEJ. The CEPEJ develops concrete measures and tools for policymakers and judicial practitioners to analyze judicial system performance, optimize time management in the judiciary, and promote the quality of public legal service. The CEPEJ also supports the Council of Europe's 46 member states in reforming their court organization, and provides as well the states and courts for a successful digital transformation on the judiciary in line with the European standards, particularly the right to a fair trial as set out in the European Convention on Human Rights. In his role, Daniel also facilitates the work of the CEPEJ Artificial Intelligence Advisory Board and the European Cyberjustice Network, which brings together over 100 professionals involved in the digital transformation of the judiciary. You are very much welcome, Daniel, and the floor is yours. Thank you.
Thank you very much for the introduction. It's a great pleasure being here in Brussels today. I would like to ask Peter if it would be possible to put on the presentation I prepared. Thank you very much. I have to say, CCBE is, of course, an observer and a very active participant and also interventor for the work of the Council of Europe, so it's much appreciated, and it's a big honor to be here today with you. The European Commission for the Efficiency of Justice, as said, for us is also a place for 46 of our member states to discuss how judicial systems can be improved, and digitalisation and artificial intelligence with, which nowadays is used synonymously, I think, is part of this. So the question for us, being the Council of Europe, is, of course, how can we ensure fundamental rights in this project or process? And CEPEJ, we are placing our work on empirical data and insights. So just for the introduction, So we provide, for example, an ICT index, where we look at the deployment rate and the usage rate, actually, of different digital tools in the judiciaries. So I just put you there a screen. You can access the site online with a QR code that is given there. So, and what we also do, so you find some numbers about this. What we also do, we look at the actual use of AI systems in our member states. So we have a resource center on cyberjustice and AI. So you see, I focus a little bit more on the public side of all this. And with this data, we follow through with more analysis. Now, I don't know, some of you might think that the biggest disruption concerning technology that the courts were facing in the last 100 years was probably Microsoft Word. I'm not sure, so I can tell you that is not the case, because there are quite some developments in the last time. But the question, so how to ensure fundamental rights, I would like to share with you 5 takeaways from our work that we have with our member states in this. So the first point I would like to make as a conclusion there is ethics are good, but regulation is better. But in the end also, without ethics, regulation is nothing in the end. So some context on this. In 2018 already, the CEPEJ provided the European Ethical Charter on the use of artificial intelligence in judicial systems and their environment. So we're just laying down 5 core principles. The first one, that in the design and implementation of AI, fundamental rights should be considered. That sounds like common sense, but talking in particular to developers and also looking a little bit back, that is not taken for granted. And in particular, intrinsic problems of the technology, which are leading possibly to discriminations, should be absolutely prevented. And also we have to ensure quality and security of processing data, in this case judicial decisions. And also we have to ensure that processing methods are accessible and understandable, which also authorize internal or external audits. So we heard about this before. AI has a little bit of a black box problem that you cannot really find out how a decision was made. And last but not least, we also advocate that users are informed if AI is used in the processing of their data. Now for this also we have an assessment tool where we have a catalogue of 30 questions how developers and public commissioners, users of these tools can ensure that this is the case. Now this is what we still consider ethical guidance. Now we move to more regulation. So as was mentioned also today, the Council of Europe just published or created the Council of Europe Framework Convention on Artificial Intelligence and Human Rights, Democracy and the Rule of Law. It did not enter into force yet. We have many signatories already, not only Council of Europe member states, but also the US, for example, is a signatory to it, but it will enter into phase after we will have 5 ratifications. So, which also then requires a human rights impact assessment for AI tools that are deployed. And sitting here in Brussels, of course, I should mention the EU AI Act, which we think is really also a very important tool because it requires fundamental rights compliance. It prohibits some AI systems and requiring also fundamental rights impact assessment. So I think that is already a good basis, and also when we work with the judiciaries, we see that this is really guidance that is appreciated and also internalized in the development. So we think that is a good step. What I said, the regulation is good, but it also needs ethics, because to make these regulations work, also to cover potential gaps, we have to have a societal consensus on what we want machines to do or not. And I think also this event underlines again that also from the lawyers' profession, we are on the same side here. The second part, move slow and do things right seems better than move fast and break things. We are talking here about a specific domain, the domain of justice. So this is not about saying books or shoes or somewhere, so which we conclude requires a specific prudence. And also when we look at the speed, how this technology is adapted, so we see that courts work on their own pace, because in the end they have to ensure the fairness of the proceedings and to look carefully at the tools they are deploying and introducing, because if this is done the wrong way, this can cause a lot of damage. And I think we have also some cases where in some countries this backfired by the application of some AI tools that led to even step down of a government in some countries. So I think that should be really considered also in the deployment. Nevertheless, in our resource center that I mentioned, we identified more than 160 different tools that courts are using. So it's not like in the judiciary nothing is happening, or it's a very conservative and non-moving environment. Really, things are happening. Maybe not at the same pace as in other areas, but it's happening, because we see also that colleagues are dedicating a lot of time to product testing and to compliance check, which we think is a good thing in the end. At the other hand, we can also see that courts in the end can move fast if they have to. I would like to mention an example in Germany. Maybe there's some Germans here. We had a kind of diesel emission scandal, which led to Musterfeststellungsklage and mass claims in this area, which resulted for some courts to be swamped with thousands of claims. And the colleagues in this region, they developed an AI tool that was preparing a decision based on the information available in the applications. They were very uniform to a specific degree, and to react relatively quickly to this. And the whole time in developing a tool and to using it took only 6 months. So all this is possible also, and it was done properly to ensure that also human rights are considered in this. We also see that it is important that first systems have to become digital before we employ AI. We'd like to talk a lot about AI, but often the basis is missing. If you don't have an e-filing system, if you don't have databases, so then you're probably not getting far with AI, and then you're also prone to violations of human rights at a later stage. So also there, we advocate for an incremental approach when implementing that such system. And another important issue we see also, and we would advocate for, that is related to the pace, and I think that was mentioned also before, is to prevent automation bias. So automation bias, if the user of the AI tool that is supposed to provide supervision is inclined to approve the response from the AI system for whatever reason. And we think, even though the benchmarks are changing, it is important to give those people who are supposed to critically evaluate these proposals, to give them also the possibilities and not to put them under pressure that in the end they only validate with it also. I think an important insight, and before we talked about the lawyer judge, I think in the other sector we talk about the robo-judge. Or let's say we used to talk about it. But the insight is also, let's not chase the robo-judge. So we notice that deployed AI systems have supportive character and are not replacing human judgment. So we see in particular that tools are applied in court procedures, process automation, recording and transcription of hearings, translation and interpretation. We see them also applied in decision support drafting tools to create templates, text modules, text summaries, calculations for compensations, and even to prepare decision proposals. But we really don't see that it's used responsibly and not used to replace the decision. We use it also to create more access, to have chatbots, to provide more information, to make justice in general more accessible. And also a big area is anonymization tools that we also talked about. We advocate also for a full publication of all judicial decisions if they are properly anonymized. And we see that most judiciaries actually are using such anonymization tools to provide this. So again there, so we see that digital procedures are mainly designed to assist judges and not to replace them. So we're in a similar situation here. And also the Council of Europe is very outspoken in this. So we have a recommendation of the Consultative Council of European Judges, which says explicitly Decision-making must explicitly and implicitly only be carried out by judges, and AI should support rather than supersede the judge. So at the same time, I think we see also more systems with higher degrees of automation. So, for example, when it comes to payment order procedures or in the areas of small claims. But there also we talk about a very specific field where we talk about specific ways of automation that are not necessarily generative AI, and that are safe in this regard also. Quickly, not the last, but one of the last things, we see a very important thing is that the judiciary should be king of its castle. The judiciary should take an active role in discussing and also deciding what are the use cases and also the limits of AI and technology in judicial decision-making. And we see good examples in some countries that this is really done. And I think also today's event is also part of this, because it's up also to the professional organizations to have a word in this. And also a positive note is that we see increasing guidance also from professional organizations, also from CCBE on this matter, but also from different courts or ministries of justice, really to educate the users also where this technology can be used. Maybe I would like to pick up one topic that was discussed also before, also when we talk about fundamental rights and right to privacy, data protection, judicial control, data sovereignty. We talked about this morning, and it's becoming increasingly important. These tools are hosted on cloud services. They are on data centers that are not necessarily in the EU, where different legislation applies, where there's also different culture, where different risks. And we see that some countries are moving over to installing their own data centers, their own cloud services, move to open source data to prevent the risks of this and to be dependent on third parties or third countries also in this regard. And a last point on this, sorry, my watch stopped moving, so I have infinite time. I don't think so.
You still have some.
Yeah? Okay, thank you very much. I think that was also mentioned before, and I think was mentioned by Maria in particular. Don't believe the hype. So we talk about a technology, and when we talk about reforms in judicial procedures, reforms of courts, and so on, we think people should start with the problem, what is there, and not to think about how to deploy or use a specific technology. In the talks we're having, what comes often is the first question, okay, how can we use now AI? And we think that's wrong. The first question should be, what is the problem of our judicial system? And then see what is the technology to address it. And in some cases, it might be AI, which, as we heard also this morning, has specific risks. And in some cases, maybe the solution is something else. And when I mentioned the resource center on artificial intelligence and cyberjustice we have in the morning, we focus on this on the public domain only. In the beginning, we were also looking at the private side, basically at legal tech that many of you are confronted with or maybe using, but we had to stop this at one point because there's so many tools out there, so there's so many tools advertised for features that you can only with difficulties verify if this is really happening, that it was basically impossible to follow. And I would like to cite from a latest policy brief from Stanford University in this area, who is saying AI companies often use benchmarks to test their systems on narrow tasks, but then make sweeping claims about broad capabilities like reasoning, understanding, and this gap between testing and claim is driving misguided policy decisions and investment choices. And I think this is also bearing a risk for fundamental rights compliance, basically, that these are probably the wrong tools also for the wrong task. So in this regard, also, we think one should really evaluate carefully what these tools are supposed to do, what they can be, and also when it comes to the use of such tools, also as was mentioned before by Maria, we think it's essential to focus more on specialized tools adapted to the judiciary. So we see many of us use already general LLMs, so like ChatGPT, Copilot, to help them in the editing of documents and so on. But when we talk about more sophisticated systems that are also used with data of judicial decisions, which are having a specific use case, that is probably the wrong way. So we need really a specialized tool, because this also will allow better data quality, first of all, and better results. So they are tools that are adapted more to legal terminology, that have a specific meaning. That is not the case for tools that can be used like this. And it is the right way to go in this direction. To conclude this whole area, so I just wanted to give you a first snapshot of what we are looking at. I'm happy also to discuss with you then further. So there's no doubt for us that the future of justice is also digital. So it was mentioned before also what can be done. We think if you cannot fight it, we should join it somehow, but in a constructive and also critical way. Because what was mentioned also before by the colleague from the Bar Association, I think it's a conscious decision also where we see our role, so where the human should be in the application of the technology and where we can bring added value and what should not be replaced by this. But saying with this, I think I could give you also a little bit an optimistic outlook of what we are seeing currently that is deployed. And I would also hope that it stays like this. And I think with this, I would like to end here. And I'd like to thank you very much.
Thank you very much, Daniel. So thank you very much for this useful insight into the institutional perspective like Council of Europe. Of course, I believe there are many questions between our participants, but I would kindly ask you to save it for the end, and we will finalize with our presentations and then go to the questions. So our next speaker is Jana Gajdosova. You are very much welcome, Jana. So Jana is the head of the Justice and Security sector in the European Union Agency for Fundamental Rights. Her current areas of work touch upon the issues relating to the rule of law, criminal procedural rights, digitalisation of justice and access to justice more broadly, as well as international security files related to the, for example, fundamental rights, implications of tackling online frauds, or accessing on using digital data for the purposes of criminal investigation. Jana previously worked in the legal service of the European Commission and as a lawyer in the governmental office representing Slovakia before the European Court of Human Rights, as well as having been an academic researcher in the School of Law at the University of East Anglia in England. Jana, you're very much welcome, and we are looking forward to see your perspective.
Thank you very much for the very nice introduction, and good afternoon, colleagues. I'm very excited to be here today, especially on this topic, and be able to share with you our very recent work on implication of digitalization of justice on fundamental rights. We indeed, just a few days ago, finalized our analysis. We are going to publish the results only in a month's time. So you are among the first ones who will learn early now from my intervention about our conclusions and our recommendations. We started in the agency. Our main role as an agency is to advise EU institutions and member states when implementing EU law on the issues related to fundamental rights. We started working more closely on digitalization of justice around the COVID time, and since then there was a stronger and stronger appetite at the EU level among the EU institutions to push member states to further digitalize their justice systems, to maybe perhaps regulate further, and at the level of member states also to really speed up the process of digitalization of justice. All that led us to think that, okay, we have to be there, we have to be able to provide the member states and the EU institutions with advice, especially to make sure that we harness the benefits of digitalization of justice and at the same time we mitigate risks. And in order to do that, we didn't want to just come up with some kind of a very vague, abstract concepts such as independence of judiciary, rule of law, fair trial, defense rights, access to a lawyer. But really we wanted to understand how things and what are the challenges and maybe positives on fundamental rights from practice. So what we did, we selected 31 use cases. We call them use cases, but basically these are the digital tools that are being used in courts on a daily basis in 7 selected member states. We didn't, or we excluded those tools that are being piloted only or tested and have not been rolled out for the whole country. We really wanted to start with the tools that are already out there and see what we can learn from those who are using them in the justice sector, be it judges, prosecutors, law enforcement, lawyers, or those more on the receiving ends, so victims or civil society organizations supporting individuals in accessing justice. So we selected 31 use cases and we grouped them into kind of 4 main categories. And here I have a slide, actually. Not sure how readable is the right side of it, but the clusters you can see, I hope, the 4 use case clusters, we cluster them on the basis of the objectives that these digital tools are trying to achieve or who they are addressed to. So the first cluster are use cases or digital tools that help to manage cases electronically, usually used with judges, among the judges, together with prosecutors sometimes, with law enforcement, and also providing access to case file to lawyers or individuals, and also e-filing. So, when you want to file a document for your case, you don't have to go in person to the office, but you can do it online. So this was the first group. The second group we looked at are the tools that are there for general public, either to help them navigate the legal systems with some legal information, or help them to report a crime if they are victims or witnesses, or ask, for instance, request a legal aid, so to fill the form online anytime, not having to go in person for that matter. The third group was video conferencing. Here again, for this cluster, but also for all the other clusters, we just went and discussed the tools, regardless whether it was a criminal justice context or civil justice context or administrative. We really went broad in that regard. So also video conferencing, in some cases, in some member states, they only used it for criminal cross-border proceedings. In some cases, we had examples where they were using it across the different types of justice, so be it in civil or criminal, that was the third cluster. And the fourth, final cluster was the use of AI tools. So maybe here really also kind of agreeing with the speakers in previous panels, but also with Daniel here, we must say that when we try to identify the actual tools that are being used on a daily basis, there is not much of an AI in the courts at the moment. What we could find were tools that are helping with transcription, or anonymization of judgments. So these are the tools we looked at from the AI perspective. And now let me walk you through what we came up with in terms of the impact of the use of these tools on the fundamental rights, both positive and negative. And maybe that's something that I would like to stress here, that in relation to all these tools, even the AI ones, even with those who are using them and were skeptical about, and were generally very realistic and skeptical, they all agree that there is potential and benefits for fundamental rights. So the digitalization actually can help to cover some gaps, not all, but some gaps that exist, provided it's implemented properly. And I think that's the important part, provided it's implemented properly, provided there are safeguards that are needed in order to really benefit from the positives and at the same time mitigate the risks. So I will just go cluster by cluster and give you some real examples, what we heard from when we interviewed judges, lawyers, law enforcement, depending on the type of a tool. We also went to interview victim support services, civil society organizations. We also interviewed the technical experts who are helping ministries of justice to come up with the tools, to design them and introduce them in courts, and really to get the full picture of the different perspectives and also individuals, as the case may be. So electronic case management and e-filing systems, they're one of the rights that has been really mentioned, something that is being impacted both positively but primarily negatively, was the protection of personal data and private life. So that was mostly related to the fact that when you are providing an access to a case file, very often what was very much welcomed by legal practitioners, especially judges and prosecutors, was that we can all share the access. It's interoperable. So law enforcement has access, prosecutors have access, we have access. It's great. Also, we can allow lawyers to have access, private parties to have access. But at the same time, there were instances where if such access is not limited or controlled, rather, then it may result in some sensitive data being revealed in public. So there were cases where a person, a party, a defendant took a screenshot and shared sensitive information from the file on the media, social media, or information about the judge, or one lawyer who is working with migration cases said, my clients are usually migrants, people who are fleeing a country where they are at the risk of prosecution, and if information about them gets to the public domain, they are basically at the risk of risking very much the life, or really they are at the risk of their security. So we have to be very, very careful here. Another right that was raised as something that is being impacted sometimes negatively was non-discrimination. These tools, when they are developed, even with the best motivation, unless there is kind of a consultation across the spectrum of different users, then you might miss on certain things. You might not think about certain things. So one example is you can file electronically documents, but in some countries you can do it only if you have ID number, a specific number that allows you to enter the system. And these numbers are only given to citizens of the given state. So unless, if you don't happen to be a citizen, if you happen to be somebody who just lives there or is a migrant or is just like doesn't have the citizenship of a given country, you cannot use the system. Yes, true. You usually have an alternative. You can go and file it in person physically. But of course, we are in a disadvantaged position compared to those who can do it 24/7 from their homes. Usually you have to, of course, oblige with the opening hours. You have to go travel, sometimes pay the costs. So there was another example where right could have been and was negatively impacted. And the final example, some lawyers also mentioned that once there are technical issues with e-filings, for instance, they might miss the deadlines, not because of them, but because of system not functioning. And then the different obligation they have to do in order to prove that it was not their fault, taking screenshots and really noting down what happened so that they actually can prove that the fault was not on their side. Moving on to another cluster, so that these are the digital tools that are helping general public to get access about legal information or actually file a complaint or report a crime, rather. There we had lawyers who are working, are representing victims of crime, and they told us that online reporting is great, it has a lot of advantages, and it's very much welcomed. But what happens sometimes are the practices that just develop around these tools. They're not really intended to develop in this way, but they do. And that's why it's important sometimes to go and talk to the, police officers or lawyers or judges to understand, okay, that's how it's actually being then implemented in practice. So in this case, actually victim wanted to go in person to the police and report a crime, not to do it online. And they went to the police station, and the police told them, but we have this online tool, so go home and report it online. So they turned the person back home, although the person wanted to do in person, and there were both alternatives possible. But probably police officer maybe was rushing home or not in a mood of hearing from a victim. So they used that as an excuse for turning the person down. That should not be happening, of course. Similar issues are with the ID numbers or numbers that are specifically given to the citizens. That happens also for those use cases that was mentioned several times. And of course, the comparable disadvantage that you have when you have these alternatives, digital and non-digital, but still those who can use digital tools, who have the skills, who are not persons with certain impairments that would prevent them from using these tools, like, I don't know, visual impairments, or persons who are elderly who would need assistance to do it, they still have to go to the offices and do it. And for them it's slower. They get information via post about a case, whereas the other party who has the email address gets it immediately. They have more time to prepare, for instance, the defense for their case, compared to the person who has to wait for the physical letter. Moving on to the video conferencing, you might not be surprised that, and there was a lot on the criminal side, but also on civil. You may not be surprised to hear that one of the most frequently mentioned rights as being impacted sometimes negatively is the fair trial and also access to a lawyer. Specifically, fair trial rights are at stake here also because of the nature, how things are, how people are behaving, how our body language is important for a judge to understand actual what the person is saying, which is sometimes not possible if you have online hearing. How lawyers would say, oh, I actually would prefer have, at least from time to time, the hearings in person, because I can read better the people, the different people in the courtroom. I can actually better defend my client when I see the witness, when I see the full in person. You might have hybrid meetings or hearings where not everybody is in a room and few people are attending online, and then again it puts them at a different level of being able to express themselves. People who are facing difficulties who are relying on a translation interpretation, then they might really be also facing certain struggles if they are on screen, appearing on screen. Access to a lawyer, I think that was mentioned already, but confidentiality of a communication between the lawyer and client is at stake here. Yes, they tell you can trust the system, you have special way you can talk to your client, and so on and so forth. It is an issue. It is an issue, of course, and it is something that I guess you would be able to talk to much more about than I. But it is something that was very prominently mentioned as something that it happens that, I don't know, a person is in detention, you need to talk to a person who is in detention, especially when people are deprived of their liberties. They tend to use online tools like, okay, talk to your lawyer, we'll let you be in this room and you can talk to them on screen. And you can hear that a person, the guard is standing just next door and can hear everything you say. Of course, then how we can talk about confidential communication. Other things or examples that were mentioned was that, of course, even the judge might want to do everything perfectly and best possible, but if for some reason the connection is stopped in the middle of the testimony, they don't know what to do, like to adjourn, wait. What if the witness is receiving instructions in the meantime? There was an example mentioned that something happened, the connection broke, and a lawyer or the person was instructing the witness how to respond to certain questions. Or an example where a defendant, I think, was broadcasting the actual hearing to the witness who was not yet called in to give a witness testimony. So, of course, these are issues that are happening, and one has to be ready to, A, be aware of them, that they can happen, and be also able to know what to do, to tackle them in a right way to safeguard the fairness of a trial. Then I move on to the fourth cluster, which is AI. I mentioned there were two types of use cases we looked at. So maybe not the most exciting ones, but that's just the reality at the moment in the courts, anonymization and transcriptions. And while they are not the most exciting ones, and maybe according to the AI Act, they would actually not fall under the category of high-risk AI, they would still bring some potentially negative impact on fundamental rights. I think this is important to realize, because the AI Act, while it is applying to the justice sector, it requires only precautions to be done, such as fundamental rights assessment, only for those tools that would qualify for as higher risk AI type of tools, which is to be seen how it's defined. But these most likely would not fall. So therefore they would say, oh yeah, you don't have to worry. But you still should actually keep your guard, because they, if used improperly, they can still negatively impact fundamental rights. And I'll give you some examples. So for the anonymization, which is of course something that is seen as a very effective way of dealing, using AI to anonymize decisions, sometimes if they are over-anonymized, they might take away the information that is important for you to understand the judgment, why the reasoning of a judgment. Example was given about the fact that there was a hate crime and the person's sexual orientation or the information about it was taken out from a judgment. So basically, you could not understand what was the hate element there, and you could not therefore understand the reasoning. And as a lawyer, then you cannot work with that case anymore. Or if they are, on the other hand, not under-anonymized, and therefore you can get hold of the information that should not be there. For the transcription tools, there are, of course, challenges for people who have certain speech impairments, or they have dialects, or they don't understand the language, or they don't speak the language that clearly. Of course, that may result in transcriptions not being very useful, or actually not complete and not accurate. So these were the kind of maybe more than the risks that we have seen. Again, there have been risks with all these use cases, but there were also a positive impacts on the rights. Maybe to conclude, I would share with you some of the ways forward we are suggesting in order to mitigate these risks, in order to ensure that we can benefit as much as possible from digitalization, but at the same time, we mitigate to the extent possible the risks for fundamental rights, negative risks, negative impact. So one very maybe obvious point is to make sure that when you are developing a tool as a Ministry of Justice or as a government, that they consider fundamental rights from the very outset and all spectrum. I gave you example of not only fair trial, I tried to give you example of data protection, non-discrimination. There would be other aspects of the rights that I could talk about. So consider the fundamental rights as such, and don't underestimate that if the tool is very simple or appears to be very simple, that nothing can go wrong. The other one is the multi-stakeholder collaboration. We've seen good examples where when tools were being designed, they were tested not only with judges, for instance, but also with lawyers or with organizations that are helping persons with disabilities who can easily point out things that they see might be problematic for them. And where data protection authorities were involved, for instance, to make sure that from the data protection angle, the tool, once it's developed, is okay and can be rolled out and used. The third point is training. Okay, we heard about that there will be new judicial training strategy alongside the new digitalization of justice strategy that Commission will issue on the 19th of November. Eagerly awaiting the text, of course, and the training is also probably not the news. Training not only for judges, of course, for lawyers and other actors who are involved in like victim support services in helping the justice to be delivered. But here it's not about training only about a kind of a technical aspects to understand how the tool works. That's very important. But at the same time, training on the potential fundamental implication of that tool, so that you can actually think about it as a judge, as a lawyer, and pay attention to these things. So fundamental rights risks should be as a part of a standard judicial training when it comes to these tools. Maintaining non-digital options to access justice, especially when people are unable to use digital services in case there is technical malfunctions, of course, where non-digital means are not deemed as a best way forward to guarantee persons' fundamental rights. You might say, when I'm having a criminal proceedings and we are discussing deprivation of a liberty of a person, it would be more appropriate to do it in person, or you as a lawyer should be able to say, well, actually, I would like to have in-person meeting, not online, and you should not be told by a judge, okay, fine, not a problem, but if you want to have it in person, we have to wait additional 2 months now, and there would be a delay, a kind of a blackmailing a person to go for an online option. Having a non-digital alternatives there will not fix everything either. And that's the final point there. We still need, because it is still not fair to have people who can use the tool 24/7 anytime, have more easier access to information, have more time therefore to prepare their case, compared to somebody who, not because of their fault, cannot use these tools, to enable some kind of a support systems for those who would be otherwise not able to use digital tools. We had examples from Italy, actually, and maybe some of you who are from Italy can confirm, about so-called proximity offices where people can go when they want to file a case online, and they get support from technical experts. So one expert said, and I have a quote here, this allows you to balance digitalization process while keeping an eye on those people, such as elderly people, who are still unfamiliar and are in difficulty of using the tools. So these are the 5 steps that if you implement them, you might mitigate to considerable extent possible negative impact on fundamental rights. And really, to conclude, I have 2 quotes that I put there, one from a judge from Italy and one from a lawyer from Poland, which I think nicely describes the different replies we received from when talking to the different practitioners about their experiences. One says, from a judge, digitalization can make the justice system more efficient and speed up decisions. That would benefit everyone who turns to it to protect fundamental rights. But the risk is that poor digitalization can instead make it harder to protect those rights. And the lawyer, I hope you can kind of concur with that. I would like the digitalization of the justice system to move in the right direction. I'd prefer to take longer, but be done better. Thank you very much. Happy to receive the questions once we have the question and answer session.
Thank you very much, Jana. So we could see that digitalization brings us a lot of positive issues, however, also some risk which we need to mitigate before implementing new tools. As you see in Jana's conclusions, so I would now refer back to Daniel, it is better to make small steps than rushing into a fast and almost stupid decisions which are irreparable. It was not totally your quotation, but it was one of your statements made that small steps are better than a fast reaching decisions. So now we will go further to the 3rd speaker. So we saved the best for the end. So the practical insight into the digitalization. So our 3rd speaker is George Zlati. So he's a managing partner of a Zlati, Onesco, Schmidt law firm with over 13 years of experience in complex cybercrime cases. George earned his PhD in law with a thesis titled Illegal Access to a Computer System, Computer Fraud, and Computer-Related Forgery. His works, including the first treatise on cybercrimes, published in Romania in 2020, have been cited in several rulings of the High Court of Cassation and Justice. In 2022, George served as an Eurojust expert in the Euromed Justice Program project, contributing to the update of the legal of the legal and gaps analysis on cybercrime. Furthermore, in 2023, he became an associate trainer on cybercrime for the Romanian National Institute of Magistracy, actively involved in the continuous training program for appointed judges and prosecutors. George, the floor is yours, and we are really now waiting that you will wake up our participants with a lot of questions.
I'm the shortest, not the best, but thanks. Peter told me make it spicy, make it interesting, so welcome to the dark side of digitalization. I usually speak in front of judges and prosecutors, so it's interesting to be here in a room full of lawyers. What I want to talk to you about in the first part of the presentation is about zero trust. In my life, I don't trust humans, I don't trust technology. Most of the time I don't trust myself, but I interact with humans, I use technology a lot, and what we need to understand is that we cannot avoid risk, but if we understand risk, we know how to mitigate risks. Okay, and we will talk a little bit about that, and we will start with data confidentiality. Obviously, I think that almost or maybe all of you are using at least one of these apps. I'm not going to talk about EncroChat and SkyACC, but if you work in the criminal law field, you know about the controversies regarding these cases. What I want to emphasize is that, for example, not so many knows that Telegram is not end-to-end encrypted by default. You need to create a secret chat in order for the chat to be end-to-end encrypted. Okay? Is it a safe app? Well, it depends. For example, if you're interacting with a client or two clients, or with a client and another colleague of you, and you are 3 people in the group chat, you should understand that that chat is not end-to-end encrypted. And all the messages are unencrypted on the server owned by Telegram. So if the server is compromised, well, bad luck. Okay, so we need to understand that. We need to understand that risk in order to mitigate such a risk. Okay, so what can we do? Well, for example, we can use technical solutions for communication like this one, but we can also use a tool, and here is an example of VeraCrypt that you can use to create an encrypted container in which you can place a file, a document, a message. Then you can encrypt the container and send the container using this one of these messaging apps. The client receives the encrypted containers, knows the password to decrypt the container, and he gets the message. So even if the device is being compromised, even if the server of Telegram, for example, is being compromised, the message or the file within the encrypted container will not be compromised. The question here is, how do you send a password to the client in order to use that password to encrypt and decrypt the container? This is another interesting aspect. You have 2 solutions for that. Maybe you create a random password for each of your case file, and the question here is, okay, and how you communicate the password in a secure manner to the client. Or maybe you can create a different password for each message that you are sending to the client, and you can use a service like the one from the right side, when you can basically send a temporary link to the client. The client accesses the temporary link, gets the password, and the link is not accessible anymore. So basically it's a one-time password for the encrypted container. Or you can use a tool like this one, where basically you inserted the plain text, the unencrypted text that you want to send to your clients. You encrypt the message using an encryption key, and then you send the message, the encrypted message, which is basically gibberish, on the right side of the slide to the client, and the client gets something like this. Okay, on his WhatsApp account, Signal account, Telegram account, it doesn't matter. Then he copies the message, inserts it in the tool, introduces the decryption key, and he gets the plain text message, okay? So you can use that in order to have a second level of security, because unfortunately we live in a state of surveillance, okay? So we need to take that into consideration. Another interesting topic is about screenshots and screen recordings. And the question here, and I'm sure that in your professional daily life, sometimes you need it to send to the case file a web page. And usually what you're doing is using a screenshot, you print a screenshot, you send the printed screenshot to the case file. Is it reliable or not? Some say that screenshots are not reliable, but you can use a screen recording that is more reliable, and you see it on the right side. The problem is that it's extremely easy to change the content of a website. And here you have an example, okay? It's the profile of Elon Musk. As you can see, I changed the text, and it's written, "Put all your trust in George Zlati," without actually modifying the content of his profile page. I just modified what you see in your browser. Okay, so you can change the content, and after you change the content, you can do the video capture screen, and it looks extremely well done. And that's an issue. Another issue is email spoofing. And what you see on the screen is an email that appears to be sent by Peter, but in reality we are talking about email spoofing. It's your email, right, Peter? It's exactly your email. Okay, obviously he gave his consent first, so what?
Next slide. This one.
Yeah. Yeah, it's fine. So basically here we are talking about email spoofing, and you should understand that any email can be spoofed, because when we are talking about the sender's email, we are talking about metadata, and metadata can be changed extremely easily. Furthermore, it's extremely easy to change the field reply to. So basically, if I'm sending this spoofed email that appears to be sent by Peter to the victim, and the victim replies to this email, Peter will not get the reply, I will get the reply, because I also changed the field reply to. Okay, so in the future, because there is a question how you can mitigate these risks, where we can talk about SPF, DMARC, and stuff like that, but this is more a topic relevant for cybersecurity. Maybe in the future, when we will talk to our clients, we will establish a unique PIN code for each client. And if the client receives an email from you, and in the content of the email there is no unique PIN code, then he should not trust that email. And maybe you can implement this in your daily professional life. And from this there is the question, okay, how do you use an email in a criminal or civil proceedings? Or how can you identify that we are talking about email spoofing? And the answer is that you should always download the original email and use the original email, not a save as a PDF file. You should actually download the original email that contains the header of the email. Because if you analyze the header of the email, like in this image, you can basically find the real IP address that was used to send that particular email. And if you have the IP address, you can use a tool to get information regarding that IP address. And if you get that information, you can clearly see that it doesn't have any kind of connection with CCB. It's related to Romania because I use my web server from Romania. Another issue is about attribution. Nowadays, we have, and this is especially important for criminal lawyers, nowadays the biggest issue is how do we actually identify the perpetrator? The perpetrator is scamming the victim using WhatsApp, for example. Maybe he's using a prepaid card, and the phone number that he's using will lead to nothing. It's unusable. You cannot get information from that phone number. Well, what you can do is use what is called a canary token. For example, here on the slides, and don't scan QR codes because it's extremely dangerous, but here on the slide, you have a QR code. If you scan the QR code, I will capture your IP address. I can also insert a canary token in a PDF file. I'm sending you the PDF file, and when you open the PDF file, I'm capturing your IP addresses. And there is a beautiful concept called scam the scammers. You should know that even scammers can be scammed. You're not getting money from them, but maybe you will get an IP address, and that can be extremely important for attribution. You should also know that you can use, for example, Wireshark, and you can call the perpetrator or a third party using Signal, Telegram, WhatsApp, and if he answers the call, you can capture his IP address. I don't think that you knew this before. For example, you have, this is a real example that I used. You can see the IP address on the slide. Why? Because basically when we are talking about Signal, WhatsApp, Telegram, we can talk about encrypted communication, about encrypted content data, but the IP address is not part of the content data. It's part of the metadata, and the metadata is not being encrypted. And how this technology works is that if you call someone, the call goes through a server from, for example, Meta or Signal or Telegram or whatsoever. But after you interact with the server, the two devices used in the calls are being connected using peer-to-peer communication. And because of that, they need to reveal their IP address in order for the communication to work. And because of that, if you are in the same network with the victim, for example, and the victim calls the perpetrator, you can capture the IP address. Obviously, this is data interception. Okay, so if you don't have the consent of the victim, as a lawyer, for example, and the authorities are the ones that are using Wireshark, they need a warrant from a judge. But the important aspect here is that you can find the IP address. Obviously, you can use these settings in advanced settings in WhatsApp in order to protect your IP address. Okay, so there, you can basically do this. The last thing that I want to talk to you is about transparency, and namely the transparency about OSINT. I don't know if you know about OSINT. When we are talking about OSINT, we are talking about open source intelligence. Here you have, for example, two tools that are being used by the police, by the prosecutors, even by perpetrators. And you should know that even lawyers can use OSINT tools that can be used to find extremely relevant information. They're a little bit of expensive. For example, the tool from Social Leaks is like 10K per year, but they can be used, for example, to get data like this one. Here you have an example. I typed gmail.com and I found a very recent data breach containing Gmail accounts and passwords in plain text. Okay? Basically, you can find out compromised email addresses. Perpetrators can do that, the police can do that, the prosecutor can do that, the lawyers can do that. Even for prevention, you can do that. Why? Because if the email is compromised, you can use another tool to find accounts associated with that email. And here is an example with my personal email account. Okay? So basically, if my account is compromised, Every account on the slide is compromised. Why? Because you can use the compromised email account to recover the access to associated accounts. That's why you should never use the same email account to create all kind of different social media accounts. For sensible accounts, for example, I don't know, for if you are into crypto, if you want to create a Binance account, create a specific email address. Don't use your Yahoo email address. Don't use Yahoo at all, if you ask me. And why is important when we are talking about transparency? And this is the last thing that I want to emphasize. If the police, if the prosecutors are using OSINT, but they are not transparent about it, how do you know that they fall in a gray area, in a dark area, in a white area? How do you know it's legal, the manner in way they use such intelligence, such data? Why is this problematic? Because a lot of data that you can find by using OSINT is from data breaches. So basically from previous offenses committed by third parties. So basically you're using such information in order to get a warrant from a judge to access remotely a computer system. So if you don't know how they get that information, how can you actually analyze from a legal point of view if the access to the computer system was done properly or not? Thank you.
Thank you very much, George, for all of you who would like to get rid of your phones, tablets. There is a basket when you will exit the room. So we come to the part of questions and answers for our participants. So are there any questions? I believe you put them down during the presentations. Please, Michael Jürgen.
I think the obvious question is why not to use a Yahoo account as a start?
Yeah, because Yahoo is dead. I mean, I think they didn't invest like $5 in cybersecurity in the last 10 years. You should never use a Yahoo account. If you have one, delete the account. If you want, we can check if your email is compromised using an OSINT tool. And yeah.
So more participants who would like to disclose his email usage case. Peter, please.
Thank you, Chair, and all panelists. I have a question perhaps for you, Jana. Have you any examples of best practices in member states where digitalisation has actually strengthened rather than undermined fundamental rights and justice systems? Thank you.
Thanks, Peter. And indeed, I did at the beginning, I did say that actually what we found out is that digital tools have positive impact on rights as well. And then later on, I gave examples of the negative impact. But it's only because our conclusion tried to mitigate those, come up with a suggestion how to mitigate those. Yes, there are plenty of examples. One of them that comes to my mind is the tool that helps to protect the victims from secondary victimization and re-victimization as well. In an online setting, when you have online hearing, victims especially who don't have to face perpetrator. Usually in courts, when you have in-person hearings, you have special rooms where a victim can provide a testimony in order not to force the victim to face perpetrator, depending on the type of crime, if it was domestic violence, for instance, or rape. And online tools can help you not to have to care for the rooms, whether the room is available or not. You can simply do it through an online means. You don't have to even ask a victim to pass by the premises because they might meet in corridors. So I think that's an example where the digital tools are helping to kind of or facilitate the right not to be re-victimized again, and help to make that a reality in a way. The other example that I could give is another digital tool that we looked at was providing persons in prisons, so detainees with the tablets. It's ways for them to be able to electronically consult their files, and importantly also to schedule an appointment with their lawyers, not necessarily to talk to their lawyers, but get in touch with their lawyers, schedule an appointment. That again is something that has its limits, but in general, then detainees don't have to wait until that's their turn to call the lawyer or use the call. If they have limitations, you can call only one number or whatever. They have a tablet and they can actually get a legal advice when and where needed.
Thank you, Jana. Daniel, you would like to?
Yeah, I would just like to add to what Jana was saying. I hope we didn't give the wrong impression. I think we don't think that digital procedures or tools always are bad for fundamental rights. That is not the idea. I think the conclusion is rather to say, so if procedures are done digitally, one has to consider also fundamental rights and not pretend that there are no safeguards or nothing. And in particular technology, we see actually a lot of beneficial uses of it, as I mentioned also when it comes to directing potential court users to make justice more accessible in general. We see chatbots in which you can interact, that you don't have to scroll websites and so on. In Portugal, for example, if you have divorce proceedings, you can even ask in English what you have to do, what steps to follow. It's not a legal advice, so this is clearly separated. We know tools who easily or automatically do summaries of decisions or text in easy language for people to understand. In general, we see also if you speed up the court procedures, if in Spain, for example, we have also an automated payment order procedure for undisputed claims, which issues this in a couple of minutes instead of months you have to wait for it. So I think in general there are definitely the positive aspects, and this is also why we think that it's the way. The only important thing is how to do it. And then also there are probably some areas where it's probably a bad idea.
Thank you, Daniel. Any more questions? Yes, please, Simone. Sorry, Jana.
I'm sorry, I have a question for George, because you mentioned at the beginning that you are training prosecutors and law enforcement, or judges rather, and you were giving us a lot of examples of how to make your data safer and unbreakable in a way.
Nothing is unbreakable.
Exactly. And what do you usually, because I'm sure they come to you and say, oh yeah, but we need that information in order to investigate crime. It's, of course, they want to do good things. They want to make sure that we are safe from criminals. But if you use all these things for them or not?
Yeah. What's the question?
How they can do their jobs if you implement all that you just recommended to implement?
I think that you already know that the fight against encryption is a tough one. And because it's a tough fight, they will always find dirty solutions like, oh, let's make it an offense if you don't give the decryption password. Okay? So it's your choice. You go to jail or you give us the password and you go to jail for another crime. So I think they will always find solution. Maybe make it mandatory for a third service provider to have a master decryption key for decryption, and so on. Yeah. Did I answer the question?
Yes, and sorry, it was a bit provocative, but these are the discussions that are currently happening at especially the EU level, where the EU should propose some rules on how to go about encryption, whether there are ways for police to still get somehow information about the content at some point, somewhere in the process, and if so, what is needed to be done. So this is ongoing, and something will be happening, maybe not as a legislation, but we shall see. The discussions are real, and there's not much of a fundamental rights or data protection experts participating and giving advice. So
yeah.
Yes, I had a question also for Daniel Schmidt on the work. There is another working group in the CEPEJ, the quality working group, that some time ago initiated a project on certification of AI tools used in court. I don't know if at some stage I lost track of that project. Maybe it was already terminated, but I was just curious to know if that was still something, because you had the charter. One of the first organizations that indeed adopted a charter on the use of AI in judicial systems. And then there was this project that was going to maybe create a kind of certification instrument for people that could then, or providers that could then get such a certification for their AI tool. I don't know if that is still a plan. And then just to already ask a question also to George, following what Jana just said. Indeed, there are a lot of practical implications of the recommendations you made. To what extent do you believe it's necessary for all lawyers to follow such recommendations, and what is the role of the bar to follow up on those recommendations? I mean, yeah, there are obviously some high risks involved, and do you believe that the bars should be more active in going really down that very specific technical recommendations that you have highlighted? Thank you.
Yeah, thank you very much for this question, Simone. Let's put it a bit differently. It took a different turn. For those who don't know, so we, as I mentioned before, in 2018, so we published the European Ethical Charter on the use of AI in judicial systems, and then there was indeed the proposal to create a certification mechanism to say, okay, so if you have a system that is applied in a court, for example, an anonymization system for court decisions or whatever, so you can get a certificate if you show that you applied the a charter on this with these 5 principles, that they are respected. Now, that was some years ago. So in the meantime, the EU AI Act happened, the Framework Convention happened, and the discussion was mainly centered about 2 things. I just mentioned one, which is the more relevant one. It's about liabilities. We talk about AI, about an area, I think, that became also clear a little bit today. So it is, to one degree, very technical. And the other question is about the reliability of information. So if you look at specific algorithms or about what systems do or can do, and depending on who's giving you the information, it is sometimes difficult to verify if this is really the case, or also the procedure how to verify this. So if you would like to assure someone that your AI system is not creating bias or discriminations one ways, the question is how you prove this. So you would probably have to disclose the algorithm, you would have to show some examples and give some other assurances, which led in the end to the conclusion that the Council of Europe is not in a position to provide reliable certification on such systems, because this is not what we do as such. However, what was considered to do instead is really where we ended up with the Resource Center on Cyberjustice and AI, is that we identify, first of all, where are the AI systems that are used, because that is also an own question by itself. So depending on who you ask, what is AI, what is not, so what system are you using or not, and then initiate discussion that is possible based on this transparency and scrutiny of the systems that are out there. And this is exactly what we are having. So this resource center that I showed at the beginning, I invite you also to screen it, developed into a place where different judiciaries are exchanging on different technical solutions, where they exchange on what worked, what did not work, where they exchange on their own internal auditing and certification measures, and which we increasingly will also add as information to these systems. So before certifying anything, the step was for us to make transparent actually what is in use, because this is very difficult. Many courts are using systems that are purely internal, and you probably don't know that some part of the information is processed. So it is still out there, not in this form, but we'll also get there in that form. Thanks.
Okay, so I think that you basically talked about encryption here. There are two subtopics here. First is personal safety. For example, iPhones and smartphones in general are encrypted by default. Macs, laptops, for example, are encrypted by default. But most laptops are not. For example, this laptop is not encrypted by default, but I have a full disk encryption for this laptop. We should all understand that encryption is extremely important because anyone can steal your laptop. If your laptop is not full disk encrypted, just imagine the things that can happen because of that. They have access to your social media accounts, they can do scams using your identity, they can access your internet banking account, they can get extremely sensible personal and professional information, and so on. So one thing is that encryption is extremely important from a personal safety point of view. Also, we need to take into consideration the lawyer-client privilege, because unfortunately, sometimes not only the client is the target in a state of surveillance, but also his lawyer. And we need to understand such a risk in order to mitigate the risk. What should the bar do? I don't know. I don't think that the bar has necessarily an obligation, a positive obligation to do trainings in this regard. Maybe it should have a positive obligation because the bar is an institution, and it should have a point of view, for example, in regard to the question of fighting encryption by infringing the right of self-incrimination, for example. So I think that the bar should have a stand on this issue because it's an extremely important issue. And honestly, I think that the bars at the national level are not doing enough in this regard. Otherwise, I think that when we are talking about how we can mitigate risks, it's all about our own research. We should understand the risks, and we should find solutions for mitigating such risks without involving the bar in this regard.
Thank you very much. So, Ian, please.
Yes. It's got to the stage in the afternoon where we're all probably getting fairly confused, so I see it as my duty to make us even more confused. It's not so long ago that, in fact, a couple of years ago, I was sitting up there and in other places with a Belgian prosecutor who used to give his Dirty Harry speech, which was along the lines of, there are bad guys out there and, just give us the tools to attack them. But the problem is, we've been talking about good encryption and bad encryption, but there are no such things. There's only encryption. And that causes problems which I think are very difficult to solve. You can say, well, we can make legislation. But then you have code, in the sense of legal code, coming into conflict with code in the sense of computer code. People have set up systems, Telegram, for example, or whatever, or Signal, which cannot be designed to have backdoors in them. And you've seen this fighting. So you've got the legal issue. Is it appropriate? There should be one there, because if you create a bad door for the good guys, you create backdoor for the good guys, you created one for the bad guys. And then you come across the, what I think is a really big question is presently playing out in the UK, the battle between legal code and software code. We're wanting to legislate in the UK, says the government, to force you to decrypt messages. Apple says we can't. It's not designed that way. And then the ultimate thing is Apple uses its commercial power. And I won't go on, but I just wanted to sort of thoroughly confuse the panel a little bit more and ask them, are these problems indeed insoluble, or how does one actually begin to moderate between all these various competing issues and concerns?
Yeah, I just want to say only one thing. This what you said, and you are correct. What you said is related to the Trojan horse controversy. If you're using a Trojan horse for good, for fighting crimes, a third party will use the same Trojan horse to do bad things. So if you're creating a positive obligation, and this is the trend in Romania also, by the way, if you're creating a positive obligation for third-party service providers to create such backdoors, Russia and North Korea and other states will try to exploit that backdoor in their own benefit. Yeah.
Maybe what I would say on that is that I think what currently helps a little bit, I think, to kind of see the positive of encryption also from the law enforcement perspective is the current geopolitical situation and what's happening. I think it's now shifting more towards, okay, actually we have to protect ourselves in the EU as well. We have to make sure that, because the foreign governments can also abuse it. So I think that kind of puts a little bit of a different perspective in the discussion. It was always there, but I think it's more kind of present nowadays, given what is happening around us. And a solution, I think Commission thinks there is no solution for the Commission for the EU. Member States should deal with that as they wish and like. And nevertheless, there are technical discussions at the moment, what is technically possible. And then the lawyers would probably come and say, okay, well, and from the legal perspective, what that means. The only sure thing is that right to data protection, for instance, protection of private life is not an absolute right. So some level of interference is possible. But where is the balance, of course? And all the cybersecurity questions come in, and then it gets very, very complex.
One more question, and then we would probably need to close with the discussion. Please.
Sorry to be the last one in the question here. Coming back to what we have discussed earlier this morning, is that not all quite trivial? Because do we have really an industry, an AI and encryption industry, which is not controlled by external powers? Is there one? Or is it just in infancy? Where do I know what to buy as a private person, or let's say a lawyer or a company, not to get into? I mean, you mentioned Apple, you mentioned Microsoft and so on. What is there which is really, which we can say it's safe? I mean, as a Q line, I don't know.
So we will provide you with three opinions now. So let's start with Jana, and then Daniel. And
so I think maybe that's the question where the EU can help with a bit. I think that's something that, I mean, Germany was mentioned, and there are some initiatives, of course. Usually it's very costly and so on and so forth. I think the EU should come in and help to combine the power, economic power, but also exchanges of these possibilities and putting it together somewhere for persons like you, but also for other law enforcement to use it. It is true that currently the discussion is how to help other law enforcement in other countries rather than how to share that widely and more widely with the lawyers. But I think that's something where EU could have a potential benefit, because they could really bring together the different initiatives. And but you're right, it's I don't know myself either. I hope George knows. I think he knows. He might tell us, actually, hopefully.
I mean, bloody hell, why is the EU or EU Commission or the EU institutions not buying equipment and technology developed within Europe, but do it in such a scale that we do not have to fight all the time against non-European. I mean, otherwise, we as individuals here, or talking for myself, of course I buy Apple. What else?
It's maybe more an opinion before I leave it to George also. But I think, I think it's a good analysis of the problem, and I think it's more for the long term, because what we are seeing, what I mentioned also, I'm not now talking about the normal consumer side, is that governments discovered this, and when they talk about data sovereignty, they try this. They go for open source, they own cloud services, own data centers, and so on. We know in Switzerland they developed their own large language model. So it appears that they are not competitive with the known ones, but I think this is definitely a way that is being taken at the moment.
But sorry, I only have got this information out of my press reading. A lot of police forces buying Palantir. Sorry. I don't see that there's so much. There might be even national, or let's say European, nobody's buying them. So if the EU, as an institution, with all this kind of intelligence, with, let's say we talked about 700 billion this morning, not doing its thing, how shall this community, or let's say the individual member states do that? We need an industry. If we don't get this industry, well, why is your nice idea about Yahoo?
Yeah, let me put it this way. There is no safety. There is only risk mitigation. That's all we can do. Just imagine, okay, let's say Nokia becomes huge again. They have a new smartphone, they have 90% of the market. If you manufacture the smartphone in China, you can talk about what is called a supply chain attack. What guarantees you have that they don't place malicious hardware in the phone produced by Nokia? All the chips are produced in Taiwan. What guarantees you have that there is no malicious code written on that chip? There is no guarantee here. So there is no safety. There is no safety.
As you say, it's mitigation. Why not to support funding which is only using EU sites and controllable sites? This is a question of trade policy in the end of the day. Come on. It's the same as if we let our tanks produce in North Korea. Are we doing that? No. At least I don't know. So, come on, we can discuss a lot about ethics, we can a lot about rules, but if we do not have the software and hardware produced in Europe, forget about this all.
Thank you. Thank you very much all. Thank you very much participants. Moreover, thank you very much today's panelists. As I promised at the beginning, that the last panel will have special meaning and purpose. I believe they really makes you alive during those late afternoon hours. So I really need to thank our panelists again. Thank you, Jana. Thank you, Daniel. Thank you, George. You were really great, and now I give the floor to our Secretary General for further information and conclusions.